participate and moderate this side event on equal access to justice for all, voices from around the world on behalf of the United Nations Office on Drugs and Crime. Welcome to all of you. We are very pleased to be attending this important third session of the Forum on Human Rights, Democracy and the Rule of Law on Equal Access to Justice for All, a necessary element for democracy, rule of law, and human rights protection, and to be able to share some of UNODC's work. My name is Elizabeth Sáenz. I am UNODC's liaison officer in Geneva, and as I said before, it is my real great pleasure to be here with you today, accompanying dear colleagues in Vienna and around the world in this event. Access to justice is a key component of fair, humane, effective, inclusive, and efficient criminal justice systems. And at its heart lies the notion of equality, that all groups in society, regardless of their background or status, can access and enjoy their fundamental rights. It also sets out that when those rights have been violated, there is a resource to justice and remedy without barriers of exception. SDG 16, and in particular access to justice, is essential to ensure the protection and implementation of human rights and the rule of law. The challenges that hinder access to justice include inadequate legislation and policies, limited financial resources, lack of knowledge of which services exist and how to access them, insufficient number of qualified justice actors to effectively deliver support, especially when it comes to addressing the structural barriers and discrimination and achieving equity. Like every other area in the world, the COVID pandemic has illustrated these challenges perfectly. The pandemic and the legal measures imposed to address it has revealed the vulnerability of the criminal justice system and the absence of strong mechanisms for accessing justice. The pandemic has also demonstrated the hidden vulnerabilities and populations within the system and inequalities in terms of the wealth distribution. And we know that things may get worse. The pandemic has also amplified, first, the lack of financial and human resources, legal aid and representation, and it had also underscored the essential nature of legal representatives, social workers, healthcare workers, working together to ensure access to justice, particularly to address violence against women and sexual and gender-based violence and discrimination. Another key aspect that on one hand has helped us survive and navigate and continue working, which is working remotely using technology, which is the use of virtual hearings, has also had an impact on due process rights and on the right to a fair trial, particularly in relation to equal access to technology. Access to justice is integral to the fulfillment of the Sustainable Development Goals, particularly SDG 16.3, and to the 2030 Agenda to leave no one behind. With the adoption of the SDG 16, the international community undertook to promote the rule of law at the national and international levels and to ensure equal access to justice for all. UNODC's efforts to widen access to justice focus on promoting policy reform, access to legal aid, restorative justice programs, and access to justice for victims of crime. It is based on an understanding that to truly realize these objectives, all those affected by crime must be able to seek redress. So during the course of this event, we will show UNODC and its partners how we have long supported member states, civil society, academia, community organizations, and justice actors to develop strategies and build capacity that empowers those groups who have traditionally been marginalized from all these processes. These groups include women, children in contact with the law, LGBTQ+, Afro-descendant, minority and indigenous peoples, and others. So this event we have divided in two parts. In part 1, we will learn about how we can measure access to justice through the data and trend analysis work done by the Data Development and Dissemination section of UNODC. This will be presented by Maurice Dunaisky. Second, we will hear our colleague Anna Judice from the Justice section of UNODC. She will outline the mandate, strategies, services, and partnerships that UNODC provides in relation to access to justice, especially in light of the pandemic and the ongoing challenges that the pandemic poses. The work of the Global E-Learning Program, Pedagogical Approach, and the available and forthcoming modules on access to justice will be presented by Sonia Rahman from the Justice section. Then we will have a second part where we will get the opportunity to listen to a range of voices from around the world on the practical implementation on access to justice. So we will start with the presentations from Joyce Matara from the Regional Office for East Africa on the Program for Legal Empowerment and Aid Delivery in Kenya, PLEAD. We will then move to a presentation on legal aid for women in contact with the criminal justice system, lessons from Liberia, Senegal, and Sierra Leone from Sven Pfeiffer from the Justice section. We will hear from Nívio Nascimento from the Liaison and Partnership Office in Brazil on making justice accessible to all in the scope of detention control hearings in Brazil. And finally, Edwin Cantu from the Liaison and Partnership Office in Mexico will speak about justice without discrimination, justicia sin discriminación. Before we start, I want to remind some housekeeping information for all of you. Please keep your microphones muted at all times. You can also place questions in the chat, noting that even though the event is in English, you can pose your questions in Spanish or in French. So without further ado, I want to invite a colleague Maurice Dunaisky to take the floor for the first presentation on measuring access to justice. Welcome, Maurice. The floor is yours.
Thank you very much, Elizabeth, for the welcoming remarks. Thank you all for being here. So what I want to talk to you about today is give you a brief overview, a global overview of where we are in terms of measuring progress on access to justice. And here at UNODC, we primarily do this through the framework of the Sustainable Development Goals. In particular, target 16.3, as Elizabeth already mentioned, on ensuring equal access to justice for all. And here we have, in a way, two sets of data. On the one hand, we have administrative data, which we can use to measure progress on access to justice. In particular here, the indicator 1632 on the share of the prison population that remains unsentenced or in pre-trial detention. And on the other hand, we have survey data, which helps us to get, in a way, at the dark figure of crime in particular. And here we have two indicators. One is the 16.3.1 on reporting of crime victimization, and a very new addition to this target, which is indicator 1633, which perhaps some of you might not have heard about yet, which I'll introduce briefly, which pertains to access to dispute resolution mechanisms. So while the first two, so the one on prisons and on crime victimization,
Hello?
Yes? Refer to access to criminal justice.
Ich bin zu Hause.
Could you mute your microphone?
Please, everybody, mute your microphones. Thank you.
Thanks very much. So while the first two relate to access to criminal justice, the new addition, so to speak, the last indicator here is much more broad in scope and also relates to access to civil justice. So with this indicator, in a way, we're trying to broaden the scope of measuring progress in relation to access to justice globally. I'll talk about indicator 1632 first. This is where we have, as it stands, most data availability at the global level and are best able to measure progress and capture trends, both at the global level but also at the regional level. This indicator really captures the extent of respect for the principle that persons should be presumed innocent until proven guilty. As I mentioned, this is based on administrative data that is usually collected by prison systems anyway, so most countries will have these data already. And at UNODC, we try to collect all of this information from member states through the yearly UN Crime Trend Survey, and then aggregate and validate these data and come up with regional estimates as well as global estimates. And what you see on the left side of the slide is that there has been very little progress over the last 2 decades in terms of improving, at least using this measure, access to justice for the prison population. We see that the unsentenced share of the prison population globally, so that's the black line, has remained relatively stable at 30%. And while there's been at the aggregate level relatively little improvement globally, we see that this hides differences between regions. So we've seen quite a substantial improvement on this indicator for the African region, where in 2000 the unsentenced share still stood at 45% roughly, and this went down to 35%, whilst we saw a trend in the opposite direction, for example, for the region of Oceania. So while at the global level it's remained relatively stable, we've seen evidence for divergent regional trends. In terms of data coverage, as the title of the presentation suggests, this is still very much work in progress in the sense that there remain significant data gaps. We need, in a way, 2 things to measure this indicator. One is the total number of prisoners in a country, and the other one is the number of unsentenced detainees. And what you can see is that when it comes to the second part, data coverage tends to decrease. Europe is the region where we have best coverage, and then when we look at a region like Africa or Oceania, data coverage, especially on the second part of the indicator, drops quite significantly. So there's definitely room for improvement here. What I wanted to mention briefly, though, is that it's, I think, important to look beyond the simple indicator of the unsentenced share of the prison population and to examine also the length of unsentenced detention. What we see here is sort of 2 case studies, one Australia, Peru. Of course, these are very different countries, but I just wanted to show you what we can do when we have information on also the length of unsentenced detention. We can see that while in Australia the unsentenced share of the prison population has increased quite steadily over the last couple of years, a large majority of this unsentenced prison population is only held for less than 6 months. Okay, but if we look at Peru, for example, on the other hand, we see over the last couple of years a steady decline in the unsentenced share. But if we look at the length of detention, it becomes clear that there's a big problem in a sense that many of these, or the majority of these unsentenced prisoners, are held for longer than a year. So this is really just to show you that it's also important to dig further and go beyond the simple SDG indicator. Okay. Just quickly on the survey-based indicators that we are using to measure access to justice globally. The first one is on reporting of crime victimization. This indicator specifically captures the proportion of victims of violence, and here we look at physical, psychological, and sexual violence that have experienced this type of violence in the previous 12 months and who have reported their victimization to competent authorities or other officially recognized conflict resolution mechanisms. This indicator really helps us to capture the confidence of victims in the ability of the authorities to help and to bring perpetrators to justice. And it's, as I mentioned already, based on survey data. And this is really important because we know that only a very small share of victims of crime actually end up going to the authorities. So if we would only look at reported crimes, so administrative data, we would not be capturing everything in relation to crime victimization that is underwater, that doesn't reach the authorities. So we'd only be looking at the tip of the iceberg, and we wouldn't know what's going on underneath the surface. And here survey data help us because with survey data we can measure pretty much everything in relation to the iceberg, and we can, with this indicator, look at the share that is above the surface in relation to the whole iceberg, if that makes sense. In terms of data coverage, we're doing much less well compared to, for example, the indicator on unsentenced detainees. What we see here is the share of countries that produce data on crime reporting and also report these data to UNODC between 2013 and 2019. And we see that for physical assault, this is only roughly 50% of all member states, and this drops even further when it comes to sexual assault. In relation to psychological violence, given that there's at the moment no internationally agreed definition of this, this is very much work in progress, and at the moment we don't have any data on psychological violence, the prevalence of the reporting rate on psychological violence. But based on this limited available data, it's not really possible to show trends over time, but what we can say is that on average, around 36% of victims of physical assault report their victimization to competent authorities, and this figure drops when we look at sexual assault, down to roughly 20%. And in some countries, the crime reporting rate is even as low as 8% for physical assault and 3% for sexual assault. So this really suggests that there are still significant barriers to accessing justice for victims of crime. Lastly, I wanted to give you a brief sort of snapshot of this new indicator, 1633, on dispute resolution mechanisms. This is an indicator that UNODC is in a way co-custodian with UNDP and the OECD. What this indicator measures is the proportion of the population who have experienced dispute in the past 2 years and who accessed a formal or informal dispute resolution mechanism by type of mechanism, so disaggregating by type of mechanism. And what this indicator tries to do is to provide a much more holistic picture of access to justice across a wide range of disputes, including land disputes, family disputes, employment disputes, and several others listed in the metadata. As I mentioned, this one is based on survey data, and we specifically need 4 questions to be able to compute this indicator, and there will be an official call for data sent out to member states in the first quarter of next year. UNDP is going to take a lead on this, but our hope is that we will be able to start measuring access to justice in a much more holistic manner using this indicator. Okay, that's all from my side. I look forward to your questions. Thank you.
Thank you very much, Maurice, for this super interesting presentation that showed us how much there is limitation in the access to justice, but also the geographic differences, the issues about reporting, the barriers to access justice, and the importance of having clear indicators and ways of monitoring the performance of these indicators. As we said at the beginning, the chat is open for specific questions to you, and let's finish the second presentation of this first part of the event, and I will give time and I will open the floor for questions. Okay, thank you very much, Maurice, once again. So now I will open the floor and I introduce Ana Giudice. I said before, she's going to present on UNODC global strategy, mandates, tools, services and partnerships to ensure equal access to justice for all, including in the framework of COVID. And here in the agenda, I have that Sonia will follow up, but I hope I have the time to introduce Sonia as well. So welcome, Anna, and the floor is yours.
Thank you. Thank you so much, Elizabeth, for chairing and introducing the meeting and taking the time for us. Can you see my presentation? Just want to make sure.
Yes, yes, we can see, but it's still not in presentation mode.
Okay, let me start. Now?
Now it is, Anna. You can go ahead.
Perfect. So I'm going to try to present very quickly a large number of items. So I will go quickly through the slides, and we can also share the PowerPoint afterwards with any participant who is interested. So my name is Ana Giudice. I work for the Justice section in UNODC headquarters, and I lead the team working on access to justice here in Vienna. So quickly, I will go through the mandates and then the tools of UNODC in this area and our approach as well. First of all, earlier this year, our executive director, Ms. Wali, presented the UNODC strategy for 2021-25. And we have a specific item under the thematic area, crime prevention and criminal justice, that focuses on access to justice. So through the implementation of UN standards and norms and the Kyoto Declaration, which I will mention in a second, we are committing to promoting the application of standards to achieve peaceful societies, access to justice, and effective, accountable, and inclusive institutions. So this is being done, of course, through the usual UNODC package of providing policy assistance, data support on data collection, as Maurice section would be doing work on the data and research, and technical assistance to member states upon request. The second point in terms of standard, of course, the standards and norms are our core standards that we work on in this issue, in this area, but we have also more recently the Kyoto Declaration that was adopted by the 14th Crime Congress that took place in Kyoto and hybrid online in March this year. And the member states again endeavored under the pillar on promoting the rule of law to ensure equal access to justice and application of the law to all, including vulnerable members of society, regardless of their status, and including by taking appropriate measures to ensure treatment with respect and without discrimination or bias of any kind by criminal justice institutions. So we have a clear mandate to support member states in implementing the Kyoto Declaration. So what is our approach to access to justice? First of all, as Elizabeth already mentioned, we see access to justice as an enabler for implementation and protection of human rights. So both in terms of ensuring the rights of those in contact with the law for criminal offenses or as victims, but also in order to ensure accountability for human rights violations. And we also see access to justice as an enabler for implementing the other SDGs. So beyond SDG 16, access to justice is essential to reach the other goals and targets of the development framework. We also base our access to justice work on international standards. I mentioned the UN standards and norms on crime prevention and criminal justice. And in particular, we have standards on legal aid, which I will also mention a little bit later, but there are other standards that are also relevant to access to justice. Our work aims to be evidence-based and data-driven, hence the importance of having data and to build policy and support on the existence of both official data, but more importantly, on survey methodology, given the issues that Maurice has just mentioned. We, in our approach to access to justice, we want to, and we are trying to center the groups and individuals that have faced systemic and historical impediments to access to justice and discrimination. So instead of having general approaches to access to justice, where we add on specific measures focusing on so-called, what used to be called vulnerable groups, we are trying to really put those groups at the center of any of our interventions. And finally, our thematic focus is on comprehensive approaches to ensuring access to quality legal aid, on police reform. And I think it's important to note that, you know, police are often the first responders to offenders or to victims. Therefore, to ensure access to justice, humane, effective, and human rights-based and gender-sensitive police are essential. Of course, efficient, inclusive, diverse, and transparent criminal justice systems, so courts, judiciary, prosecution, prisons and other institutions are key, as well as addressing more victim-centered approaches to criminal justice and building programs for supporting and protecting victims of crime. So briefly, I will mention some of the tools. I will not read them all, but you have them on the slide. So we have a full set of tools on legal aid, which are all based on the UN principles and guidelines on legal aid. Sorry, I'm not giving you the full title, but you will find them in all these tools. The new upcoming tool that will come in 2022 is a new legal aid assessment tool, which is a very detailed tool that was developed through a expert process with a number of expert meetings where we brought together experts online. And this is where the COVID pandemic somehow helped us to bring together experts that we would not necessarily have been able to bring together in previous years. We also have new training, new e-learning modules coming up, and Sonia will mention those. A strong focus on quality of legal aid services. In the area of police reform, a number of tools that have been developed a couple of years ago are now getting a renewed attention, given the renewed attention, I would say, to policing, and in particular to the issue of use of force and police accountability. So the UNODC OHCHR resource book that we published in 2017 on the use of force and firearms will come out between this year and next year in Arabic, Spanish, Portuguese, and Russian. And we have a lot of interest from member states and professionals on this issue. And the UNODC handbook on police accountability, oversight, and integrity is also available now in Spanish and will come in Russian next year. And we're also working now on, as a follow-up or in parallel with the development of the Mendes principles on e-learning modules on investigative interviewing with the Norwegian Center for Human Rights. And finally, around the issues of victims and restorative justice, colleagues have developed a second edition of the Handbook on Restorative Justice Programs and a training tool. And we have a Handbook on Justice for Victims that is a little bit dated, but can still be referenced. And a lot of tools on child victims and witnesses of crime as well. So the final point I think that I wanted to make was in relation to the COVID-19 pandemic. And I wanted to reference the UNODC UNDP guidance note on ensuring access to justice in the context of COVID-19. It was prepared relatively rapidly after the beginning of the pandemic and issued in May 2020. It looks at measures to be taken in 3 phases. So in preparation, when in the situations of pandemics and other crises, in response, and in recovery phase. I think we all hope that we would be in recovery phase by now, but as someone already mentioned, we might not yet be there. And of course, these phases can overlap. The guidance note looks at some critical elements to consider to address short, medium, and long-term impact of the crisis, and it includes recommendations and examples that we have collected from all around the world. Yeah, I think it's still a very topical document that you can also reference in your work. Again, I don't have enough time to go into details. So finally, to mention partnerships and specifically in regard to the issues around racial justice and racial discrimination, I want to mention that UNODC is the lead of the criminal justice pillar of the UN Network on Racial Discrimination and Protection of Minorities. And we have been quite active this year in raising visibility of these issues within various fora in Vienna, as well as developing tools and bringing together, I would say, the criminal justice actors with the human rights actors. We are supporting, we will be supporting dissemination and implementation of the recommendations of the High Commissioner on the transformative agenda on racial justice and equality. And we're very much looking forward to a very active 2022 in this area. We also have strong networks with professional networks, of course, individual UN agencies and civil society organizations. And thank you, and you have my contact if you want to follow up on anything.
Thank you very much, Anna. I hear an echo now. Thank you very much for that fantastic presentation, showing us all the UNODC's tools that exist to address access to justice. It's incredible to see the range of normative but also technical assistance tools that you have developed. You have highlighted something that is crucial, I think, for all of us, is the interconnectedness of all the SDGs. I mean, we worked towards achieving one particular goal on our area of specificity, but we know that when we work on these targets, we are addressing other areas of development, and that is also fascinating. I think that in your presentation, it's very important to see that many of these tools, UNODC is also working in partnership with other UN agencies, but also civil society and other organizations. And I think this is good for our audience to know. And finally, I think that what you mentioned about COVID, I very much see, and I like that you have already showed the longer term kind of vision, because I think COVID, I think I said this at the beginning already, but I think that COVID is just ongoing. And as the financial impact, the inequalities in the distribution of vaccines and medication, jobs and etc. are impacted, we will see that issues related to justice, access to justice will certainly also be affected. Thank you, Anna, for your presentation. So I want to give the floor now to Sonia Rahman from the Justice section. She's going to be presenting the Global E-Learning Program and the pedagogical approach and the available forthcoming modules. Thank you, Sonia, and welcome.
Thank you so much, Elizabeth, and thank you, Anna, and Maurice for your excellent presentations. I'm just, sorry, if you could just bear with me.
Yes, your presentation is there, Sonia.
Oh, perfect, thank you so much. So it's a great pleasure to be able to present today on the UNODC Global E-Learning Program. My name is Sonia Rahman, and I work as part of I'm part of the Global E-Learning Program. Over the last 11 years, the program has worked on providing a range of services, including the production of self-paced e-learning modules in English, the design and creation of instructor-led courses, the production of e-learning tools in various languages, and we also provide e-learning online and offline training through the UNODC learning management systems, and the delivery of mobile training units and the establishment of e-learning centres for many of our counterparts around the world. The focus of my presentation today is going to be on the creation and development of self-paced e-learning modules. And I think what I'd like to highlight from the outset is that in developing all our e-learning modules, and in particular the modules that I will briefly outline later in the presentation on access to justice, we have utilised a human rights-based approach. And we adhere to the principle and the right to non-discrimination. We have tried as far as possible to ensure gender and global representation in all of our e-learning modules. So I think that the most important question to start with is, how do people learn best? So we have utilised the latest pedagogical approaches in the design of our e-learning programmes and modules. And we really rely on this research to make sure that the learning experience is as engaging as possible and that it fosters knowledge transfer. And I think there's often a popular misconception about e-learning modules, namely that they are merely summaries of lengthy handbooks or technical assistance tools. But what we have seen is that actually people learn best when they are actively engaged, and therefore we create hands-on activities. We draw from our participants' vast experience and professional expertise, and we use a variety of instructional methods, and we promote collaboration in all of our work. So for us, it's important to actually use the experience that our colleagues have and our users have in the development of our e-learning modules. We work with a range of users, in particular law enforcement officials, other criminal justice actors, as well as academic institutions and members of the public. So, as you can see, we really believe that the effectiveness of our approaches, applying highly engaging modules that stimulate or engage learners actively, has really made us able to increase the number of users that we have on our platform. As you can see from the graph, we started off in 2017 with 21,400 users, and at the moment we have 115,200. We also have seen changes in terms of gender representation. So amongst our users, so we have near gender parity in terms of our users. We have 57% of our users being women, and 43% are men who use our modules. And in developing all our modules, as I mentioned before, we utilize the latest pedagogical approaches, and we try to ensure as far as possible that we make the modules no more than 60 minutes long to ensure that the participants are actively engaged throughout. We make the modules self-paced, so we enable the learner to go at the pace that they wish to learn at, and to accommodate their busy schedules and work commitments. We try to make them highly interactive to ensure that the user's attention is retained throughout. So we use lots of text, images, quizzes, exercises, scenarios that they can apply to their day-to-day life, and animations. And we, as I mentioned before, we utilize human rights-based approaches that are non-discriminatory and representative of gender and diversity as per UN guidelines on this. And we cover all the mandates of UNODC, from drug policy to wildlife crime to crime prevention and criminal justice and anti-corruption and the prevention of terrorism. And we really believe that e-learning tools are a way to complement face-to-face capacity building, and can actually be used as a prerequisite to many of our activities and technical assistance provision. So we utilize in all of our modules pre and post tests, which we believe enable the trainers to gauge the participants' level of expertise in a particular area, and also the transfer of knowledge that has taken place from participating in the program, in the module. So just to briefly outline some of the modules that we have produced on access to justice, we have a module on implementing a coordinated criminal justice response to gender-based violence against women. And this is actually going to be pilot tested with police and criminal justice actors in Bosnia and Herzegovina on the 1st of December. we have a module on access to legal aid for women in criminal justice systems, which our colleague Sven will outline in further detail. We also have modules on investigative interviewing and forthcoming modules on enhancing the quality of legal aid. We also have a number of modules on policing and police-related issues. And we have 3 modules focusing particularly on human rights and policing. And I would like to leave you with our new e-learning platform, which is a much more user-friendly interface. And you can learn more about our online catalogue and our services on this platform. And if you have any further questions, please don't hesitate to get in contact with me. Thank you.
Thank you very much, Sonia, for this very informative presentation shared with all the participants. And I've learned a lot already, and congratulations on increasing the number of users exponentially, literally, during the pandemic, which is also telling us the importance of, you know, using the tools that the circumstances are telling us are the most useful. But thank you very much. I hope that all the participants and people interested in these topics can also contact you, Sonia, I guess, to get more information about the materials that are available. So we have finalized the first part of this event, and I'm now going to open the floor to any participant that is in the audience to either give us I'm going to open 2-3 minutes of questions. You can on Teams, you can see at the top there is a little sign with a hand. You can click there if you want to raise your hand to ask a question, or you can also place your questions on the chat. So here in the chat I have from Eduardo, greetings, very important subject and agenda, best wishes from Brazil. But the floor is open for 3 minutes in case anyone would like to place a specific question to the presenters so far. Any question, comments? It can also be comments. It can also be some particular experiences from your countries, from wherever you are participating. So I see that no questions are coming, no hands are raised. So maybe colleagues, the last chance to place a question. Okay, since I see that there are no more questions coming, I'll make just a brief summary. So we have heard from Maurice issues around data and trend analysis measuring access to justice. And then we heard from Anna and from Sonia about UNODC's programs, normative and technical tools available, as well as the e-learning tools, which is also all very interesting. So I'm going to move on to the second part of this event, which focused on presentation of the technical assistance program on addressing equal access to justice. And we will hear different experiences from around the world. So the first presenter is Joyce Matara from the regional office in Eastern Africa. Welcome, Joyce. I hope, yes, I see you there. Welcome to the event. And Joyce is going to be presenting the program for legal empowerment and aid delivery in Kenya, please. And yeah, welcome, and the floor is yours. We can see your presentation already. Now you went back to non-presenting mode. Are you there?
Yes,
Joyce?
I'm here.
Okay.
I'm here, Elizabeth.
Okay, now I can hear you. So the floor is yours. Welcome.
Thank you. Thank you very much. Let me put up my presentation. You can see it?
Yes, just
okay.
Put it in presentation mode.
Yes. That's okay?
Now is perfect. Thank you, Joyce. Welcome.
Thank you, Elizabeth, and thank you, colleagues who have preceded me. Trying to unpack this huge and exciting project in 8 minutes is an uphill task, but I'll do my best. What you can see on the screen introducing the PLEAD program is, people sitting under a tree and trying to resolve their disputes in an, hopefully amicable way and using alternatives. And this is ideally the vision of PLEAD, that we can be able to bring people together to use alternative justice mechanisms so that they can be able to amicably resolve their issues. Of course, in conformity with standards and norms that are set. Yeah. A brief overview of PLEAD is that it was launched in 2018 and it's implemented in 12 counties in Kenya. It's anchored in the government blueprint, which is a Vision 2030, and of course the SDGs, including SDG 16. And it's the largest program in the justice sector within sub-Saharan Africa, and therefore we are really excited to be part and parcel of this program. We work with the co-implementing agencies is UNDP, UNODC, and National Legal Aid Service. I work with UNODC, and therefore I'll be speaking a bit more about them. What is our target? We hope that in the 5 years that we'll be implementing this project, we'll have a 50% reduction on backlog of cases by 2022, 30% reduction of pretrial detainees, and hopefully 25% of men and women in Kenya, especially in the marginalized counties, which I have indicated, will have access to justice. As you know, DC, we work with 5 government agencies, which is the judiciary, prosecution, probation, witness protection, and the umbrella body, which is NCAJ. It's an umbrella body of all the justice actors. These are our generally our outcomes. Enhancing of access to legal aid and assistance. This is implemented by UNDP and the National Legal Aid Service. And the other 3 are implemented by UNODC, where we support the judiciary to strengthen the court administration and case management. We support the other justice actors, the prosecutors, the probation officers, witness protection agency to enhance their efficiency. And at the end of the day, we hope that when they're empowered, their efficiency is enhanced, then they will be able to give better service to the Kenyan people. And lastly is to improve coherence, cooperation, and collaboration within the umbrella body, which is NCAJ. Generally, this is the map of Kenya. It's a pretty map. And what is shown in blue is where we implement. As you can see, it's barely half of the country. But the strategies and policies that we develop have a nationwide effect. So that is what we aim to do, just come up with policies that will support and enhance access to justice. A brief overview of the Kenyan justice system. And this will be able to now help us contextualize why we need to have alternative ways of accessing justice and to enhance access to justice. The serious backlog in the report by the Judiciary 2020 report, it shows that the backlog of cases stands at 341,000 plus. The cost of legal representation in Kenya is very prohibitive, very expensive. Kenya is vast, and especially in the marginalized counties, you find that the courts are only in the major towns, and therefore people have to travel long distances to access. Very few people have faith in the criminal justice system because of the corruption and discrimination that prevails. Transparency International ranked Kenya 124th of 180, which isn't very encouraging. 90% of disputes, you find that people opt to use informal processes, whether they conform to, Bill of Rights, they conform to standards and norms of criminal justice is another question. And that is why you will get to see that we as PLEAD have come up with the AJS policy. When we look at our prisons, we are our population, sorry, this was a typo. Let me go back. Our population is over 50,000, yeah, and not 500, 50,000. Actually, it's 54,000. Sorry about that. And 48 of that are pre-trial detainees. You find that the prison capacity is 26,000. Therefore, at 50K, it means that we are overpopulated by 200%. Women in Kenya, this is the statistics, that 40% of women in Kenya are likely to face SGBV of some sort. And this number percentage increased, especially during the COVID pandemic, as is the case with many other places. But it's not all is doom and gloom. COVID-19 presented opportunity for Kenya to embrace technology and innovation through e-learning, video conferencing. There was more adoption of alternatives to imprisonment, which led to a reduction by 12,600 of prison population. So this is quite encouraging. I'll quickly just speak about what UNDP and NLAS are doing, but I'll substantively speak about UNODC. UNDP work with civil society organizations, and in their midterm report of 2021, they reported that there was an increase of access to justice from 14% to 29%. That is in a period of about 4 years. And they have done 613 legal aid clinics, and you've seen the figures there. They aim to forge partnerships with the duty bearers and the community civil society organizations. On the other hand, National Legal Aid Service, which is a quasi-independent government body, it seeks to broaden its reach to offer legal aid services. And it's a new partner in PLEAD, but they have already opened up 7 offices in 7 counties, which is encouraging. Generally, UNODC takes the bulk of the work, and we report on outcome 2, 3, and 4. And these are some of the key achievements. Diversion as an alternative to prosecution was never there in Kenya, and through the PLEAD program, we've been able to support the prosecutors to develop the diversion policy and diversion guidelines. And this is very important for us, especially because now diversion, being an alternative to prosecution, is encouraged, or it's prosecutors are told that they must consider diversion for the vulnerable, for children, and for petty offenses. And in the last 4 weeks or so, we've had, for instance, arson cases of where students in schools are just burning up their dormitories and all. And we ask ourselves, should these children have, a criminal record? Should they be put through a criminal justice system, or are there ways we can divert these cases and offer them? So we can be able to empower them in other ways, as opposed to putting them through the justice system and arresting them. And so these are discussions that are going on, and the policy and guidelines on diversion have been taking place and being implemented. Plea bargaining as an alternative to trial is one of the other documents that we supported in the development for prosecutors. We have the AJS policy. As I mentioned, 90% of disputes in Kenya are resolved through systems outside the formal court. And therefore, there was need to develop a policy so that it can have a human rights approach to it, so that the framework can, have the duty to respect, protect, and transform through the human rights framework. Sonia mentioned about the, when she was talking about the UNODC Global and e-learning program. This was very exciting for us because in the aftermath of COVID and the excesses of the police, we were able to partner with the global e-learning. And as you can see, we have over 60K learners, 60,000 learners who have enrolled, and over 24,000 have completed the training. The training has 7 modules, which touch on a wide range of issues for the National Police Service, on SGBV, use of force, crowd control, etc. Use of community service orders is also one of the achievements, where probation officers can be able to use this so that we reduce on prison population. At the point of sentencing, probation officers can be able to recommend community service orders and monitor that. Just quickly also on some of the achievements, we've provided strategic support in development of strategic plans, excellence charters, establishing and operationalizing change management offices and initiatives, curriculum development, communication support, and also providing hardware support to these institutions, especially in the wake of COVID. We were able to ensure that the equipment that has been purchased is able to enable the e-justice actors to embrace e-justice. Support to active case management is also one of the things that we've been able to do as UNODC to enhance mobility. We've purchased vehicles, we've purchased motorcycles, just to enhance the mobility of the actors to reach the vulnerable and the marginalized communities. Lastly, learning and innovation. We have provided a lot of technical support in the development of curriculum and training manuals, support to the Judiciary Training Institute and the Prosecution Training Institute, and undertaken a number of face-to-face trainings as well as e-learning trainings. Thank you. That is all from me.
Thank you very much, Joyce, for your presentation. Very interesting work. Congratulations. In Kenya, a big country, big problems, but it's incredible how you've managed to integrate creative ways of addressing the particular cultural realities of the country, etc. For the sake of time, I'm going to open if there is one burning question for Joyce, and for respect to our other speakers, I would like to move on, and if there is time at the end, then maybe we can open the floor for questions for all the speakers. But we have 3 more speakers, and I want to make sure that they all get the time schedule. So one burning question for Joyce. I see that there is an interaction in the chat, which is great, and colleagues are responding. So any questions for Joyce? No? So I don't see any hands, so I'm going to move to my next presenter in the agenda, Sven Pfeiffer, who's going to present us Legal Aid for Women in Contact with the Criminal Justice System, Lessons Learned from Liberia, Senegal, and Sierra Leone. And Sven, it's not only a pleasure to see you, but great to introduce you to this side event. So the floor is yours. Thank you.
Thanks so much, Elizabeth. It's a great pleasure to see you and others in this event. I won't have a PowerPoint presentation, so no problem with technology for me. I have the pleasure to present our project to improve access to legal aid for women in Western Africa, which was funded by the UN Development Account and is a collaboration between our office and UN Women in coordination also with OHCHR. And it brings together the work that we've been talking about on SDG 16 with the other important work on gender equality under SDG 5. It had a strong focus on intersectionality and adopted a human rights-based approach. So we think it's a great example, and we're also encouraged by the evaluation findings that are emerging as the evaluation is still ongoing. So this project we implemented from May 2018 to June 2021 in 3 countries, in Liberia, Senegal, and Sierra Leone. And I have to say that especially thanks to the very hard work by field colleagues from UNODC and UN Women in those countries, the project has been a success. It started, as most of our projects and programs, with a comprehensive assessment of the national legal aid systems in each country and the challenges faced by women in particular who are in contact with the criminal justice system. And this project focused on specific groups of women, particularly survivors of gender-based violence, as well as women accused of crimes or imprisoned. And it highlights some of the common challenges that I'm sure you're familiar with also in other countries. for example, that women victims of rape and sexual assault are often treated as the guilty party, and the police and prosecutors, on the other hand, are hesitant to complete investigations, especially when the perpetrator is their family member. And even though these are very serious and should be serious offenses to be dealt with by courts, there's often a great pressure on women to go for the traditional solution in which there's reconciliation or non-judicial means. However, the victim is often blamed and shamed and not really protected, and her rights are disregarded. On the other hand, women in conflict with the law have few financial resources to pay for legal assistance, and that means that they often remain in prison after they should have been released. And free legal aid that specifically targets women is often their best, if not their only chance to claim redress and to realize their legal rights. On the side of the duty bearers, one of the key challenges is that in legal proceedings, women rely only on a handful of dedicated legal aid providers, but those providers are often self-funded and they don't have the long-term institutional support that they would need. And this has particularly been the case in Liberia and Senegal, which, unlike Sierra Leone, do not have a comprehensive legal aid legislation and policy. However, since all three governments had shown interest in working on this topic, the project basically seized this opportunity and brought together quite different countries, even though they are located in the same region. I have to mention that the project followed a theory of change that is based on our joint practitioners toolkit on women's access to justice programming, which was developed by UN Women together with our office, with UNDP and OHCHR. And accordingly, it includes three main components. The first one is focusing on the legal and policy framework concerning legal aid. Secondly, capacity building for legal aid service providers. And thirdly, on the demand side, empowerment of women to use legal aid. The first two were basically our responsibility, and the third one was realized through UN Women, through a scheme of providing financial grants to civil society organizations in those countries who provide legal aid. However, as for many of us, COVID-19 has disrupted this process somewhat, and as a result of that, legal empowerment of women and supporting actually the delivery of legal aid services has become the focus of the project, and most funds actually went to the civil society organizations. Thanks also to the flexibility of the UN Development Account colleagues and DESA in New York, we were able to respond to the increased demand for legal aid as a result of COVID, and particularly among female detainees and female victims of violence. So that meant that additional grants from the money that we couldn't spend on workshops, for example, went to the NGOs to deliver essential services, in addition to raising awareness on how to use those services. Concerning the impact, I think it's important to look beyond the immediate outputs. We of course have statistics. Given the limited number of funds that we had, they're not as impressive as the ones from our PLEAD colleagues, but we do know that over 800 justice professionals were trained and indicated that they increased their knowledge, and that almost 800 women benefited from specific legal aid, legal awareness activities. We also have a tool that was piloted during different training of trainers workshops, and only at the end finalized, so we were able to incorporate findings and feedback from the users into the final version. And based on the tool, we are also going to shortly publish a legal aid e-learning tool on legal aid for women to provide easy access by trainees during and after COVID-19, and maybe enhance some blended learning approaches, combining online with in-person learning. But I think it's more interesting to mention that the ongoing evaluation has revealed much more interesting findings. For example, for the duty bearers who are in contact with the project, it had a double impact, our evaluators said. On the one hand, the duty bearers realized that legal aid for women is worth spending time on and provides more effective, efficient, and adequate judicial processes. And on the other hand, they were supported to better implement the existing legal framework or to prepare themselves for the time when new legal aid legislation might come into place. For women who use legal aid and who received support by the CSOs that our project managed to support, they were really able to access legal, social, and other types of essential services. They gained access to the justice system, obtained a fair or maybe at least fairer judicial process. Some of them were released from custody and unlawful detention. And in particular, the project helped victims of sexual crimes or domestic violence who are often without legal support and legal representation, don't have access to justice and let alone redress and protection. We have to acknowledge that the project could not or only modestly contribute to advances in policy and law, but its key added value and a lesson that I would like to share is that it provided flexible funding to established legal aid providers. And that has enabled them, firstly, to reach more clients, secondly, to increase their legitimacy and their partnerships vis-a-vis justice institutions like the police or prison authorities and others, and to really work with them hand in hand. Some of them reported that they are now called by the police when the police is taking women into custody, and they know that it enhances the process for all institutions involved. And thirdly, it enabled those legal aid providers to advocate for normative changes. So it wasn't the usual top-down approach where we invite policymakers, legislators for workshops, but we did empower through this project legal aid providers themselves to advocate with their own national, in their own national contexts for the development and the implementation of legal frameworks. For example, in Liberia, one of the grantees contributed to the development of a new legal aid policy and also supported the adoption of the domestic violence law, which was a long time coming and had started much earlier. So just to conclude, I would like to share with you and present the case of one of the beneficiaries, because I think that it really illustrates how life-changing and life-saving legal aid can be. Elizabeth, don't worry, it's almost over. So Miss L is in the capital city of one of the 3 countries, and she has slight mental and some physical disabilities. She was pregnant when she was arrested during a police raid connected to the COVID implementation measures. She couldn't pay the fine that was imposed on her and possibly also didn't really understand why she was arrested or what she had to do to get released. She was brought to prison because she couldn't pay the fine and comply with police orders. Her entry into prison was not recorded. She missed her court hearing. She stayed in the prison for months. She gave birth in prison without medical assistance. Her health quickly deteriorated and she was not able to sufficiently tend to her baby, whose limbs were attacked by rats. And during one of the monitoring visits paid for by the project, the legal aid provider identified these types of violations, arranged for basic medical care, and actually obtained her release on parole through an emergency court procedures. And they're continuing to provide her with psychosocial support. And so just to leave you with this case, which really illustrates, based on one woman that we were able to help, why we need more funding for broader programs embedded in broader criminal justice reform, such as the colleagues in Kenya are doing with PLEAD. Thank you very much.
Thank you very much, Sven, for your presentation. I was going to say, my comments to you were around how humble you were in describing the impact of the project, even though when you said about the training of 800 people in the legal system, I say, imagine the exponential impact that can have. It means hundreds more or thousands more benefiting from these 800 people trained. But you definitely touched my heart with this last example, and I think that yes, that's a real plea to donors, to the international community, to all of us, to really look into the issues of access to justice, because in the end, it's lives, it's people, and again, I want to close before I give the floor to Nivio on the issue of interconnectivity of the SDGs, because in the end, with this example, you illustrated everything: health, justice, gender, many other areas that are touched with your work. So thank you, Sven, for sharing this experience. And I give now the floor to dear colleague Nivio Nascimento from Brazil. And Nivio is going to talk about making justice accessible to all in the scope of detention controls hearings in Brazil. Thank you, Nivio. The floor is yours, and I see your presentation is ready. Welcome.
Thank you for the opportunity to share our experience in Brazil on detention control hearings, which in Portuguese is audiências de custódia, in some legal systems, arraignments hearings. Basically, it's the presentation of a detainee to a judge in the period of 24 hours. And since 2019, the Office of UNODC in Brazil has been working in the scope of this program called Fazendo Justiça, literally in English, Making Justice. And it's a partnership between the National Council of Justice, UNDP, and UNODC, with funding from the executive branch from the National Penitentiary Department. Just explaining very briefly, the program, it started in 2019. Brazil has some systemic challenges, like 70% of overcapacity. In 2015, the Supreme Court declared an unconstitutional state of affairs, and we have many problems related to decentralized prison systems, poor institutional articulation, and so on. It's an innovative response because the judiciary has a leading role. We have a partnership with executive power, civil society, and academia, and it has a strategy for action in all the 27 Brazilian states. Brazil is a very wide country with and very complex, so the program adapts itself to each region in each territory. This is the program strategy. We are on the gateway on the pretrial detention hearings or detention control hearings aspect, but it's an integral action related to the prison system in Brazil. Here is our initiative on control detention hearings, audiências de custódia. Our goal is to strengthen the mechanisms, especially to prevent people to enter in the criminal justice system in Brazil, especially in the 27 units of federation. We have 4 pillars. First one, international standards and guidelines. I will show a little bit of what we have produced. Advanced studies network and dissemination of good practices by involving magistrates and other people involved in these hearings to strengthen and to share good practices. On-site expert advice. At the very beginning of the program, we have 1 UNODC staff in each of the 27 federative units of Brazil. Now we have 13, but next year, with a better situation regarding the pandemic, we will have 25 states covered by the program. And the 4-pillar management, monitoring, evaluation, everything we do, we measure, we gather data, we help the judiciary in identifying trends and threats regarding the custody hearings. Here it was one of our let's say big products. We have general guidelines on decision making and also decision making specific crimes. It was 2 manuals that we produced in partnership with the people we have in the 27 units of federation and also by our team in Brasilia. We have a manual on social protection, thinking about how to deal with people that passes through these hearings before and after the hearings. We have, in some cases, problems of torture, in other people that have that live in vulnerability and so on, and we helped articulating this through these manuals. Torture, it's another big reason of having this detention control hearings in Brazil, and the use of handcuffs and other instruments of contention. These are the manuals, but these manuals translate into e-learning that we are producing with our colleagues in Vienna. They translate into training in the States, and they translated into telecoms and other forms of technical assistance, including podcasts we are thinking about producing to share the content with our public, which is mainly magistrates. We have also some innovation. We have just launched a manual on the best way to do the architecture of the hearings, the distribution of the space in articulation and coordination with the other manuals we do. And some key results, for sure, I'm not saying that the only initiative conducted by UNODC led to these results, but for sure we have contributed with the work we have been doing in the last 3 years with the Brazilian judiciary. Decrease of 4% in pretrial detention decisions. In these hearings, the magistrate has to decide on releasing or sending the detainee to pretrial detention. 5% increase in the release decisions. 81% increase in the reports of torture. It seems a big number, but actually torture is not well covered by these hearings, and we are doing a lot of effort in strengthening this part. 17% increase in referrals to social service teams. This is something really important to stress. We have made a big effort in strengthening, especially the social network related to the hearings. And increase of 90% of psychosocial teams in capitals of Brazil federal states, and we have made a lot of effort in this. And for the first time in years, the number of people imprisoned in closed and semi-open regime fell from 709 to 682. This has for sure some influence of the work we are doing on pretrial detention, an influence of the program Fazendo Justiça in general, and also some effects of the pandemic. We are going to our 4th year of implementation of this program together with the National Council of Justice. Up to now, we have 38 staff allocated for this project, but we are probably raising the number of staff next year to 45. And I would like to end my presentation thanking all the support we have from our colleagues in Vienna, in special from the Justice section, in putting this program into movement. So thank you very much for the opportunity, and I will be here in the case you have questions and doubts about our initiative. Thank you.
Thank you very much, Nivio, for this very illustrating presentation. There is the mic open. And I have to say that it's impressive to read to learn about the results of the work, especially issues around 81% of increase of the reports of torture. I think that this is important because it reflects that people know and people are aware of unlawful practices, but also impressive 91% of psychosocial support for people in prisons. I think this is very important as people, you know, these again, looking at the overall human dimension of this problematic, that you know, people get the support and the guidance that they require in such difficult moments, yeah, and challenging moments. So thank you very much, Nivio, for telling us about the experience in Brazil. And I'm going to, I don't know if there is one very short burning question. I think we should. I don't see any in the chat. So let's close it here, Nivio, and I will invite Edwin Cantu from our Liaison and Partnership Office in Mexico. He's going to speak about justice without discrimination, and hopefully we will still have a couple of minutes at the very end for whoever wants to raise questions to our distinguished presenters. So Edwin, the floor is yours. Thank you.
Thank you. Good morning, good afternoon to everyone. Let me just share my presentation. Just share screen. So I'm gonna make it quick so that we can make it on time. I believe we're on time already. So I'm gonna have just a few minutes to share with you an experience we had at UNODC office in Mexico regarding the implementation of the Justicia Sin Discriminación, or in English, Justice Without Discrimination campaign for the promotion of human rights of LGBTIQ+ population. This is within the framework of the event we're having right now, Equal Access to Justice for All. So what does Justicia Sin Discriminación campaign, what does it consist of? It's an advocacy campaign promoting messages related to the elimination of all forms of discrimination and violence against lesbian, gay, bisexual, trans, non-binary, queer, and intersexual people. It's basically a campaign. We are working this alongside with local government institutions, embassies, particularly Canadian Embassy and the UK Embassy in Mexico, civil society organizations, the academic and private sector. So we're basically pulling different organisms, different institutions in order to collaborate along with the campaign. And it is based on the diffusion of messages and materials on diverse platforms, particularly on social and printed media. We have generated some infographics, we have generated a guide. We're constantly publicizing messages related to the elimination of discrimination and violence against this population. And these messages and materials are particularly expressed through social media, but there's also printed media that is promoting the message of the campaign. So we're gonna have a quick overview of the timeline, what we've done in order to support the equal access to justice for LGBTQ population. So this campaign starts way back at 2019, in which we collaborated on a joint initiative on the prevention and the elimination of conversion therapy practices, which are based on the idea that sexual orientation or gender identity is a preference that can be corrected. So there was this need to properly address conversion therapies, and conversion therapies are practices that are still being implemented today as we speak, that are based on physical violence, sexual violence, psychological violence in order to correct the sexual orientation or gender identity of people. So this is obviously against human rights, and there was the need to identify these practices, also to understand that people that undergo through these practices are victims of different types of harassment, different types of torture, different types of sexual violence. So it was needed, it was needed to start promoting the message that these types of initiatives must be banned. So a reference guide, a booklet was developed, and it is shared both physically and electronically, and it is currently only in Spanish. So this is the guide that we developed alongside with a university, a local government institution, and a civil society organization. We, along with other academics, we finally had the first draft and final draft of this guide, and it is being disseminated, and it properly addressed why the need to ban conversion therapies and how are these practices harmful. So the counterparts agreed on the generation of a campaign and a hashtag with two objectives. First of all, it was the promotion of the guide. We had generated this material. Actually, at the end of this presentation, I'm going to share with you the material through a link. So it was needed the promotion of the guide, and also to share messages related with the importance of LGBTIQ+ people to properly access to justice systems when victims of conversion therapy. So our intention was also to get to the people that were victims of conversion therapy in order for them to properly access justice. So this was way back at 2019. Of course, we had an interesting response. We held an event with local and national counterparts with the sectors I've mentioned before, and this was a very great first step forward on human rights, on addressing human rights of LGBTQ+ people from the access to justice perspective from the office. So in 2020, basically last year, we continue with the promotion of the reference guide, the booklet I've said before, and the campaign and the hashtag with the assistance of counterparts and allies such as influencers and musical performers. Since we got the collaboration of the private sector, there was this one big music company that allowed us to reach artists and musical performers, and many of them replicated through social media the messages we were putting out in order, related with the elimination of discrimination and violence. This was very, very positive in order for them. Well, it was positive because it allowed us to reach other types of audiences, no? A major audience rather than our own social media. Of course, we had this impact that we are interested in following. Two state legislatures, Mexico City and the state of Mexico, they're different, added conversion therapies to their criminal code or their penal code. Anyone who tries to cure sexual orientation or gender identity may face criminal charges. So this was an important point to stand out, because not only just because of the publication of the guide and the campaign, but there was this context in which two state legislators properly addressed the topic, and it is quite interesting because the legislators had the guide on their hand while they were discussing this. So it was quite important for this in order to identify the impact of this initiative. And well, of course, we identified new challenges. It was identified that training is necessary for first responders, investigation police, and prosecutors on how to investigate events that may constitute conversion therapy. All right, so if there is identified that conversion therapies or whoever incites or practices conversion therapy is committing a crime, well, of course, there is the need to train first responders, police, and prosecutors on identifying identifying conversion therapy practices, no, and how are these publicized. They are not out there publicized as a conversion therapy. They're named with with other titles, no? So it is we identify now the need to strengthen the training in regard to investigating this events, no? And we also generated infographics to address interventions of police agents with LGBTIQ plus people, like the one we're sharing. This is an infographic we generated with general guidelines in order for police to orientate their intervention or their attention when he or she is in presence of a person from the LGBTI community. This was quite important since not all the states has a specific protocol on how to address people from the LGBTIQ plus community. And of course, this may interfere with the access to justice for people when they are victims or survivors of crime.
Edwin, you have 1 minute. If you can start closing, please.
Sure. Okay, I'm gonna do it then real quick. Just a quick overview of what we've done last year. As you can see, legislators have the guide on their hand. And for this year, we continue with the campaign. We started as a very close collaboration with the private sector. We started to generate new materials regarding how to eliminate discrimination and violence against LGBTIQ plus community and the private sector, and we start exploring new ideas on how to eliminate harassment on the workplace based by sexual orientation or gender identity. And also, we generated new materials to properly address how violence and discrimination also surrounds the schools and family environments. To close, I would like to share some ideas. The collaboration with governments and private sector and academic sector, civil society organizations is very important in order to keep on promoting this. Also, another idea is not everyone has a clear notion of what discrimination or what violence is. Therefore, there's a need to start simple and have an interactive dialogue with allies, counterparts, and general public in order to generate more complex ideas, such as great hate crimes. The concept of hate crimes it's complicated since not everyone understands what discrimination or violence is. And also, it is important to introduce concepts related to sexual orientation, gender identity, or gender expression to personnel from security and justice institutions in order for them to recognize how to properly address people from this community, and therefore have positive steps on their access to justice. These are some ideas I'd like to share, and I'll close with this. Thank you very much.
Thank you very much, Edwin, for your very interesting presentation. I have to say that all presenters were very good in keeping their allotted time. I think that we just had a bit of a miscalculation at the beginning. So I'm going to, in your presentation, I think that I would highlight the vulnerabilities of people and how being in the LGBTIQ plus groups, makes people more vulnerable. But I also like what you mentioned about the momentum, I think that we have this way of impacting and making changes in policy, which is either top down, bottom up, but how when you have allies and bringing together different actors in the society, not only government, but the civil society organizations, then you can gain the support that you need. And I think the example you have given us really illustrates that. So we are running 2 minutes late, but thank you, Edwin. Before I close the event, I really want to give the floor to anybody who has a burning question, but also remind you that colleagues in Vienna, Anna, Sonia, are very much open to receiving your questions either through the chat or by email. They all provided you with their contact details. So 1 minute for any burning question for the distinguished presenters. I see nothing. Well, obviously everything was very clear and very interesting. I have to say, I feel very proud of my UNODC colleagues, actually. Anna, you want to say something before we?
No, I wanted to echo what you just said. I wanted to thank all the colleagues for coming in so on short notice and presenting. And I also feel very proud of all we're doing. So thank you.
Yes, amazing. It's impressive. Okay, so if no questions, no comments to the presenters, definitely a big thank you. Kudos to all of you for your interesting and very important, relevant presentations. Of course, thank you to all the participants, our audience that was there. There were some interesting comments in the chat, and I'm sure, Anna, you and your team are going to follow up on that. To OHCHR, to the High Commission, of course, on Human Rights, many thanks for organizing this event and for allowing us to, like you said, Anna, last minute being able to organize this side event on UNODC's work. To our colleagues, both in headquarters, for all the great work that you do in preparing technical assistance tools to support member states in addressing these problems, but also to our colleagues in the field for the clarity and the structural way in which you use those tools and adapt to the realities of the countries where you are working with our organization. So big kudos to all of you. And again, a closing remark to say that definitely access to justice is very much linked to human rights and has a human rights dimension, but it's also a developmental. It touches on so many other sustainable development goals in addition to 16 and the specific 16.3. So with this, again, thank you to my colleagues for inviting me. I felt very honored, and to remind you that I'm here in Geneva, very always willing to support you and connect you with the UN agencies and other organizations here in Geneva. So thank you again, and I close the event. Thank you, everybody, and goodbye.
And thank you, Elizabeth. Thank you so much.